Parloa.
Definitely make your way back if you're interested in the next session, which is going to be our Fireside chat on how trust becomes your sharpest competitive advantage. And for that, I'm very happy to announce our next speaker lineup, which is Dr. Caro and Dr. Philipp. So please give a warm welcome to them.
Okay, welcome to our Fireside chat today. And right before the lunch break, we want to dive into legal regulations, easy for the lunch break. So in particular for the European AI Act. And we want to look into some opportunities and challenges and what it means for us as a company and for conversational AI and agentic AI. So I'm Dr. Carolin Gütschow, just want to pronounce my name. And I'm Director Legal at Parloa, and I have been on this journey already for 3 years. And with me on stage is Professor Dr. Philipp Hacker, one of the leading voices in the AI regulation, and he advised the European Union on the AI Act and also advises now the new AI office. So this is us, and we want to talk about the AI Act, and we want to dive into what it actually means in practice and also for companies like us. For us in Parloa, compliance with the AI Act has always 3 different paths. We look at our core product, an AI system with limited risk, but we also, of course, look into external AI tools when we use it. But also as a company, we look into AI literacy trainings and also joining the European Commission AI Pack, for example. And when we develop new features, we ask us simple 2 questions. Does it work technically? And on the other side, is it transparent and trustworthy? Because compliance is pretty essential for us on a daily basis. And this gives our customers trust, and also especially in finance and also in insurance industries where responsible AI is not optional. So for us, it is not just compliant, it is a market differentiator. So Philipp, how do you see it? What is your thought on that? What is the main opportunity and what are the challenges with the AI Act?
Yeah, thanks for having me here. I'm a legal scholar, so I want to say that, of course, it's a regulation, so I can see only opportunities. It's the best thing in the world. No, just kidding. In all earnestness, I have to say that the AI Act is certainly far from perfect. However, there are a number of things that you can actually do with it in a quite meaningful way, even for a company. So, for example, of course, you can use it to kind of brand your product as AI compliant. And I think, AI Act compliant. And I think that that's actually a very positive label that you can put on your product, and not only for the EU, but also for other jurisdictions that are now increasingly adopting similar frameworks. Not all of them, of course, but if you look at Brazil, they have a bill under consideration that's very, very similar, very much inspired by the AI. California, of course, then you have South Korea. So across the world, you have a number of jurisdictions where this can actually help, and I think it helps generate trust in your products. On the other hand, we won't deny that, as we said, the AI Act is far from perfect, and it creates a number of frictions. First and foremost, there is the narrative problem, I think. It's increasingly clear that a lot of people are talking about the AI Act who have actually close to zero knowledge about the AI Act, but who fear it a lot. There's also a number of people who have a lot of knowledge about the AI Act who are also not very content, and that's that's me in part, or I should say, perhaps at least. But the good thing, I think, here is that the narrative can be broken. The narrative often is that, the AI Act is impeding and stifling innovation. But you can see companies like Parloa or others on stage here that show that Europe is not only world champion in regulation, but can also be a world champion in, specific AI applications and AI models. What I see as another problem, other than the narrative, is really when it comes down kind of to the nitty-gritty of how things are operating. And on the one hand, conversational AI, which is the rage now on the topic of today, is only what's called limited risk under the AI Act. So the AI Act has different risk categories. You have prohibited stuff, the crazy Chinese-style social scoring, for example. You have high-risk use cases like employment or credit scoring, and then you have limited risk. And for limited risk, you only need to deliver transparency, right? And so that's the case for chatbots in general. But if you kind of don't pay attention, use them in certain ways, or if you fine-tune them heavily, then you could actually become subject to other types of rules in the AI Act, high-risk rules, general-purpose AI model provider rules, and then it becomes a lot trickier. So those are some of the kind of hidden traps that you want to know about, and that's why compliance by design, I think, is so important.
Okay. So this is mainly the topic for the European Union, for Europe, right? So, but as we know, it's also developing very globally. And when for Parloa, we do have our US entity, the Parloa Inc., and we are also in the US and in the European Union in these different kind of markets. So we know that there are different kind of approaches throughout the world. So how do you think about this? Like, there's a narrative that is saying like the US tends to be unregulated or kind of unregulated, and whereby the European Union is always over-regulating things. So what is your perspective on this?
Yeah, that's actually what a lot of people say. I mean, it's easy to come to this conclusion looking at it from the outside. Particularly on the current administration, the U.S. is deregulating, the EU is overregulating. Let's see who in the audience who would agree with that statement, broadly speaking. Let's say U.S. is deregulating, EU is overregulating. I can see a lot of hands. Okay, thank you. I'd love to talk to many of you about this because I think that that statement is actually quite fundamentally wrong on both ends. At least it has to be nuanced in certain ways. Why this? Well, if you look at the US, it's patently clear that, of course, they have perhaps even more pro-innovation strategy than Europe has, and of course, they don't have a federal act on AI regulation. But you can see all these mini AI acts popping up in different states. So you have it in California, in Colorado, in Virginia, in Tennessee. And if you want to roll out a product across the US, it's not one piece of legislation you have to keep in mind, but actually 50 different ones, or let's say 22 or so, only in democratic states. Even Texas now has an AI safety bill, which is interesting. It was signed into law. It was signed into law by the governor, was not vetoed. So that's one thing to consider. In the EU, you have one framework. In the US, you have, 30 plus. Look at liability, for example. So we have always product safety law, product liability law. Liability means something goes wrong, who has to pay? In the US, what do you have? Right, product liability. Is product liability tough in the US? Damn, it is, right? You have triple damages, you have all kinds of stuff, you have pretrial discovery. Now, the big question always is AI a product in the sense of product liability? And guess what? A Florida court just ruled that yes, it is. Just like, it actually applies to all software. It's not a discrimination of AI or something. It's actually, it's fairly sensible because this is not too much of a difference, you could say, from a legal and industrial perspective between a bottle of water and AI when it comes to consumer harm. So that is something that applies in the US. We also have product liability in the EU, but again, we have only one set of rules. It was recently updated, so it includes AI. But with one set of rules in the EU, you do not have punitive damages, you do not have triple damages. In the US, again, it's stateside, so it's state-based, so you have 50 different regimes, and they're much tougher than the EU correspondent. And then finally, think about copyright. Have you heard about, let me know, who has heard about the Anthropic, the Bart's versus Anthropic settlement, the 1.5 billion settlement? Okay, that's not too many people. It's a copyright lawsuit where Anthropic just agreed to pay $1.5 billion to a bunch of authors because they used their works for training. That is a U.S. lawsuit. So you have U.S. copyright law, which bites. And so I really want to say that the U.S. is far from unregulated. They don't have an AI Act, but they have all kinds of different stuff. Now, on the other end, in the EU, are we over-regulating? I think, yes, there has been too much. There has been too much in the sense of too many different types of digital regulation and don't fit. There's a thicket of regulation that's really hard to get through as a company. When it comes to the AI Act itself, I want to say that in many respects, it brings to the table and makes compulsory best practices that are already prevalent in industry, like data governance. I mean, you do data science without data governance, you're doomed, right? So now you have to document it more, and I can see that that's a nuisance, and it does create compliance costs, particularly in high-risk sectors and in GPI model provider sectors, but it's not actually outlandish. A lot of this stuff is based on industry best practices. So again, I just want to nuance this a little bit to say that actually, if you look at the bottom, I think the two are not so different. What is often different is the VC culture, it's the mindset, it's the access to talent, but it's not. There are also empirical studies that show that it's not regulation that's the big differentiator.
So you mentioned like copyright law and all of these different kind of laws that are kind of apply, right? So, and also for us, it's always challenging, let's say, how these kind of new regulations like the AI Act are integrated into the existing law, right? So we face, like, for us, always the GDPR was always the gold standard, and still, like, we use this, and also together with the AI Act, different kind of laws apply, like the European Union Data Act, and also DORA for the financing sector, and of course GDPR. So we are trying to have like a holistic way of looking at these things. But I also think like what we built it already with the GDPR is like a good start point for innovation, and also the AI Act, right? So this would be for us, it is a foundation to have innovation. And I think once the companies are ready to adapt, they can use this. So what is your perspective on this when it comes to the future? What is the view on this? Because this is just like the start, and it will, right, so give the new way of thinking and creating law. What is your perspective on that? What will come?
Yeah, so I think there's various ways in which the AI Act and other types of regulation will impact conversational AI in the future, and I think it's not to be underestimated. To be quite honest. You rightly said that many companies already have a GDPR compliance stack, and that's something you can build upon to then upgrade this, let's say, to the AI compliance stack. What I see as particularly important are 3 points, I think. So the first one, when it comes to conversational AI, the first one being transparency. As we already said, chatbots are part of limited risk. So, under the AI Act, so you need to be transparent. But what does that mean? First, you got to tell your customers, the people that are interacting with the engine or with the conversational AI agent, that this is AI speaking. It's not some worker who's doing 25-hour shifts, but this is not a human being. And I always imagine my grandmother, being out there saying, "Oh, these girls are working all the time." It's like, no, this is actually AI generated, and this is interesting because it becomes kind of a problem or an interesting case for how do I actually design this so it is not cumbersome, so that every 10 seconds there's a beep that says this is AI speaking, But on the other hand, it has to be conspicuous. It has to be done in such a way that consumers actually know that they're facing AI and not some customer agent. So that's the first thing. Second thing, or the second thing under transparency is labeling. So from August 2026 on, and that's both for the knowing that you're talking to AI and this role, from August 2026 on, providers have to ensure that the models that they build, Gen AI models, are labeled, that the kind of output is, to the extent possible, identifiable as Gen AI generated. So if you have images or videos and you want to sell these models in the EU, just like we've seen, the Synthesia and all this great avatar stuff, there needs to be a watermark or something similar in there to enable NGOs and other interested parties to know that this is AI generated and not real. Basically, every time that it looks authentic, but it's not. And why is that so? Of course, we want to protect election integrity and all these things. So that's important to know. Also, as a deployer, you want to choose a model that has this functionality integrated, at least from August 2026 on. Then there is another point, which we touched upon briefly earlier in the beginning, when we said, you gotta be careful about these a little bit of hidden traps. And that's basically, first of all, fine-tuning. I mean, what is one of the main application cases, I guess, of GPI models and agents? You take an off-the-shelf model and you fine-tune it to your use case so you can use it better in your specific customer basis. Now, if you do that, the question arises, if the model becomes different, do you, as the entity who just uses this either proprietary or open source model, do you become what's called the provider? So the person who actually has to follow and obey to the AI Act rules. And that is a question that is not properly answered under the AI Act. In fact, I was quite active in the negotiations of the AI Act at the very end. And I teamed up with a computer science professor, and we made a suggestion how to do this, how to regulate. People didn't have time to do this. The whole AI Act was literally done in 38 hours, a 38-hour marathon negotiation, famous long nights in Brussels, and they did not have time to look into this. So now we're standing with this kind of mess in parts. And the Commission, fortunately, now has issued guidance. So the takeaway point here is, if you want to fine-tune a model, you want to be sure that your fine-tuning uses less than 1/3 of the flops, the floating point operations, the calculating steps, vis-a-vis the original model. If you're above that 1/3 flop threshold, then likely you become the new provider. And that means you have to follow the GPI model provider rules and not the original provider, the Metas, the Alphas, the Mistrals of this world. So that's one thing. And the other main takeaway, I think, is if you use a GPI general purpose AI model, an LLM or another Gen AI tool, say a conversational AI agent, and your customer relations manager has the great idea of not only using it vis-a-vis customers, but then saying, hey, I have this call out there and I have so many applications for this new position. Let's use this really just real quick to, narrow that down to the top 10 positions. And then I will look at all the rest myself. I will do it manually, The moment you do this, you use a GPI model for a high-risk use case, like recruitment, boom, you become a high-risk AI system provider. And it's not to scare anybody. You're perfectly fine doing this. This is not forbidden at all. But you have to be aware of that fact because that entails other duties under the AI Act that are a little tougher to fulfill than just the transparency rules. Okay, so that's a second takeaway beyond the 1/3 flop threshold. Be sure to write in your internal guidelines. Don't use this for high-risk purposes, a GPI model, unless you have really verified with the compliance team and potentially company leadership.
So you pointed out like transparency and also responsible AI or responsible use of these things as key points, right? So for us at Parloa, it's also pretty important also to building the trust with our customers. But there's already change on the horizon, what we can see. So, we are also looking for simplified rules and having clear, also for our customers, certainty. They need that, right? And we are also trying to look into the future and look at these kind of developments like the omnibus regulations or other things that are coming our way. So I would be interested in your outlook, or what is your outlook on this, that how will the regulation shape the technology? You mentioned that already that there will be changes, but what do you think about compliance by design and also that the regulation should be technology neutral? What do you think about that as an outlook?
So yeah, I'm talking a lot to policymakers both in Germany and at the EU levels. And I think that's a great question because if I had a crystal ball and I really knew this, I wouldn't be here, but rather on the Bahamas, I guess. But the main point is that the EU Commission has seen that the maze they have created in terms of different and partially overlapping and not very well-fitting digital regulations is not a great selling point for innovation in Europe. And that's, I think, absolutely the correct analysis. So first, what's happening is that this digital omnibus that you mentioned is an exercise in trying to trim this thicket and trying to parse out where, for example, overlaps between the AI Act and specific types of sectoral regulations, say medical device regulations, banking regulation, etc., can be avoided. And I'm actually currently running a project precisely on this, and we'll present this to the Commission in, I think, precisely 4 weeks. So that's going to be something to watch. It's in December, middle of December, they will present the plans of what is supposed to come there. And I think that hopefully will bring some alleviations to some of the compliance problems that we're seeing at the moment, particularly at the intersection of different sectors. Second, really important takeaway, as you mentioned, technology neutral laws. So for example, people say, hey, it's all about AI agents, but AI agents, they're not mentioned in the AI Act, they're not mentioned in the GDPR. Is this something that was missed, that was left unregulated? No. Why that? Because this is the magic of the law, which of course cannot anticipate all future developments. Rather, you use strategically vague or neutral terms. So the GDPR obviously applies to all data processing, irrespective if this is an agent that is AI-based or an agent that is rule-based or whatever. So a lot of this is already covered under technology neutral law, like the GDPR, and also the AI Act, of course, applies to AI agents, mostly in the sense of limited risk. But I want to stress that sectoral regulation is, I think, where we're headed much more. So I think the EU made took a bold step with the AI Act, horizontal regulation, and now what we're learning is that oftentimes it's smarter to actually update the rules that are more sector-specific. So if you think conversational AI in, say, an autonomous car, you won't see that in the AI Act, in an update to the AI Act. Rather, you will see rules on this in an update of specific automotive regulation for type approval, etc. So that's where you want to be looking. And I think with that, it's important to keep your eyes both on the Brussels and on the Washington and U.S. front, and plainly speaking, also in other parts of the world. Of course, you have selling there, because we see a lot of new things on the horizon. For example, last thing perhaps on this is transparency, because we already said that transparency is a big thing under the AI Act, but the real challenge for transparency does not actually come from the AI Act, but it comes from the, what would you say, ladies and gentlemen? Where is the real the legal basis for challenge and transparency? Right, exactly, the GDPR. Yeah, I heard it many times. The GDPR, our beloved GDPR. Why? We have a new ruling, the Dun & Bradstreet ruling from the CJU, where the CJU specifically says if you use software, AI, vis-a-vis data subjects, any person, then in some automated decision-making setting, then that was credit scoring actually, then you need to be able afterwards to say which features basically were the relevant ones for that decision, both locally and for the context of that decision and globally for the entire model. And that is, of course, a challenge when you run huge models to give global explanations. And so again, we have the AI Act, but it's important to have a more holistic picture, as you also mentioned, for keeping an eye on other developments where that spurs XAI, I guess, kind of explainable AI on the one hand, but on the other hand, you really need this interface between law and technology. And so to end, I just want to say, I think compliance is great. It's such a fun area to be working in, precisely because you have these meeting of the minds between tech and law. And so we've had the pleasure of working together before. We did some events and stuff at Parloa, and I think this was good fun, actually, to bring these people together, and I think that's what compliance should be like.
Thank you so much. I think it's exciting times ahead still, and challenges also, but I think we can agree that this is like a foundation for growth, innovation, and things that are changing, and it's going to be interesting. And I think we can talk more hours and minutes, whatever our time is over, but we are happy to chat with you during the lunch break. So just join us for more insights and exchange. So thank you so much, Philipp, for today's conversation.
Thanks, Dr. Caro.
Thank you, Dr. Philipp, and thank you all. Thanks.
Parloa.